Preserving Your Rights Edition. Practical Legal Training Module, Part 1. From Magna Carta to Modern Courtroom Procedure. Most people believe the legal system is about truth, but the legal system is actually about process. If you do not understand how to move inside the system, you can lose your rights even when you are correct. This training is designed to teach you where American law comes from historically, why courts function the way they do, what rights are protected by the Constitution, and, most importantly, how to preserve your rights through procedure. Because rights without procedure are not protected rights, they are only opinions. Section 1. Where American law comes from, the real bloodline.
This chapter is sponsored by TheySource, the San Antonio-based raw sea moss and natural herb online store, serving customers who want real wellness products without the guesswork. TheySource offers raw sea moss gels, sea moss capsules, plus a wide selection of loose herbs, herbal powders, and herbal capsules, with options for curbside pickup, local delivery, and shipping support. TheySource emphasizes quality and transparency, including sourcing and documentation practices like certificates of analysis, so you know where your sea moss comes from. This is tied to their sea moss supply, so customers can shop with confidence. Please visit their website and use discount code POD10 to take 10% off your next purchase at theysourcesales.com. TheySource Sales is spelled THEYSOURCESALES.com. Now back to our episode.
American law is not random. It has a clear origin. The legal structure in the United States traces back to England and is heavily influenced by English common law, the Magna Carta tradition, the Westminster court system, equity courts, chancery, religious courts, ecclesiastical courts, and later Enlightenment philosophy that shaped constitutional design. This is the legal family tree. 1.1. 1066, the Norman Conquest, centralized power. In 1066, William the Conqueror took control of England. This created a new reality. Law began shifting from local tribal rules into a system controlled by the crown. The king became the central authority. This is important because courts eventually became instruments of centralized government. 1.2. The early religious legal systems, ecclesiastical courts. Before modern legal systems became unified, England had religious courts called ecclesiastical courts. These courts were run by the church and often handled matters like marriage disputes, probate and inheritance, moral accusations, church authority issues, spiritual or sin-based offenses. These courts were separate from the king's courts. This is where your religious aspect study is correct. Religion influenced law because religious institutions had court authority. Over time, their power weakened as national courts strengthened. 1.3. 1154 to 1189, Henry II and the creation of common law. King Henry II is considered the father of English common law. He strengthened royal courts and created traveling judges. Instead of every village having separate rules, the law became more unified. This created the concept of standardized rulings, legal precedent, jury-based decisions, and court systems based on record and procedure. This is the birth of what we call common law. Common law means law built from court decisions and precedent. This is the root of modern American law. 1215. The Magna Carta, limiting government power. The Magna Carta is one of the most important legal documents in history. It forced the king to recognize something powerful. The king is not above the law. The Magna Carta introduced early principles of due process, lawful judgment, lawful detention standards, property protections, limitation of arbitrary punishment. This becomes the foundation of rights-based constitutional thinking. One of its most famous principles is the concept that a person cannot be imprisoned without lawful judgment. This directly influences habeas corpus thinking. 1.5. Westminster courts, structured courts, and writs. England developed the Westminster court system. These courts relied on a writ-based structure. A writ is a court order that commands action. This is why writs are so central in legal history. If you wanted relief, you needed the correct writ. This is why legal procedure became powerful. 1.6. The Court of Chancery, Equity Law, and Fairness. Common law courts were rigid. They could not always produce fair outcomes, so people began petitioning for fairness. This created equity law through the Court of Chancery. Equity introduced injunctions, trusts, fiduciary duty, equitable remedies. Equity is one of the biggest reasons trust law exists today. This is important for nonprofit law and property preservation. 1679 Habeas Corpus Act. Habeas corpus is one of the most powerful legal principles ever created. It forces the government to answer, by what authority are you holding this person? This is a protection against illegal detention. Habeas corpus is one of the strongest legal checks against tyranny. 1689, the English Bill of Rights. This document limits government power further. It reinforces principles like no cruel and unusual punishment, no excessive bail, lawful procedures for governance, rights of citizens and representatives. This directly influences the American Bill of Rights. Section 2. Colonial America and the Rise of Constitutional Thinking. The American colonies inherited common law courts, jury trial traditions, writ systems, equity principles, and property rights philosophy. Colonial America became a common law society, but America also began to develop a new philosophy. Government must be built from the consent of the governed. 1776, the Declaration of Independence. The Declaration of Independence introduced Enlightenment thinking, natural rights, liberty as inherent. Government exists to protect rights. Citizens have the right to alter or abolish government if it becomes tyrannical. This is philosophical law. It ties directly into Socrates, Aristotle, and later Kantian ethics. 1787, the U.S. Constitution. The U.S. Constitution is essentially a machine designed to prevent tyranny. Its design is based on one core assumption: human beings abuse power, so power must be divided. This creates separation of powers, checks and balances, federalism, state versus federal authority. The Constitution is the highest law of the land. 1791, the Bill of Rights. The Bill of Rights protects citizens from government overreach. It includes rights like free speech, protection from unlawful search, due process, fair trial rights, protection from excessive punishment. The Bill of Rights is the American continuation of the Magna Carta tradition. Section 3. The most important principle in American law. Rights do not protect you if you do not preserve them. In court, the law is not only about what is right. It is about jurisdiction, procedure, deadlines, rules of evidence, proper filings, and the official court record. A person can lose a case simply because they filed incorrectly or failed to preserve the issue for review. This is why procedure is power. Section 4. The 5 legal categories that control courtroom power. To operate inside the legal system, you must understand 5 major rule books. 4.1. Constitutional law. This includes the U.S. Constitution, amendments, state constitutions, and constitutional case law. Constitutional law sets the boundaries of government power. 4.2. Statutory law. Statutory law is law passed by legislatures. This includes federal statutes, U.S. Code, state statutes, and city ordinances. Statutory law defines crimes, civil remedies, penalties, and legal rights. 4.3. Case law, common law, precedent. Case law is the legal interpretation of statutes and constitutional principles. Courts rely on precedent. Precedent is why similar cases are decided similarly. This is the backbone of common law tradition. 4.4. Procedural law. Procedural law tells you how to move inside court. This includes civil procedure, criminal procedure, evidence rules, appellate rules, and local court rules. Procedural law is the difference between winning and losing. 4.5. Administrative law. Administrative law is law created by government agencies. Examples include IRS rules, HUD rules, EPA rules, licensing boards, child support enforcement systems. Administrative law is powerful because it controls many areas of modern life. Section 5. The rulebooks you must know. State level. Most states have legal codes that operate as manuals. The major codes include 5.1, Code of Civil Procedure, State. Civil procedure is the rulebook for civil lawsuits. It controls lawsuits and petitions, service of process, motions, discovery, hearings, default judgments, temporary restraining orders, injunctions, summary judgment, trial procedure, civil appeals. If you do not follow civil procedure, you can lose even if you are correct. 5.2. Code of Criminal Procedure, State. Criminal procedure controls the criminal system. It governs arrest procedure, bail hearings, bond conditions, pre-trial detention, motions to suppress evidence, plea bargaining, trial rights, sentencing rules, probation violations, post-conviction relief. This is where constitutional protections are enforced or violated. 5.3. Rules of Evidence, State. Evidence rules decide what information the court will allow. Evidence controls admissibility, relevance.
Hearsay rules, authentication, expert testimony, objections, chain of custody. Evidence is where many cases are won or lost. 5.4. Rules of Appellate Procedure, State. Appeals are not retrials. Appeals are a review of legal error. Appellate rules govern deadlines, notice of appeal, briefing requirements, the record on appeal, standards of review. If you do not preserve the issue at trial, you cannot raise it on appeal. 5.5. Local court rules. Every county and court system may have local rules. These rules govern formatting requirements, page limits, required forms, mandatory hearings, filing and submission requirements. Many people lose simply because they did not follow local rules. Section 6. Federal Rule Books. Federal court is different. Federal court is a separate legal universe. Federal courts operate under 6.1. FRCP, Federal Rules of Civil Procedure. This governs federal civil lawsuits. 6.2. FRCRP, Federal Rules of Criminal Procedure. This governs federal criminal prosecution. 6.3. FRE, Federal Rules of Evidence. This governs what evidence is admissible in federal court. 6.4. Federal Local Rules. Each federal district court has its own local rules. Federal courts are strict about formatting, page limits, and deadlines. Section 7. What it means to preserve your rights. Preserving your rights means you create a legal record that proves you raised the issue properly. A right that is not raised correctly is often considered waived. The court may say, "You did not object. You did not file a motion. You did not preserve error. You missed the deadline. You did not exhaust remedies." This is how people lose. Section 8. The Rights Preservation Ladder, the Courtroom Formula. This is the formula for preserving your rights. Step 1. Identify the violation. Ask, what right is being violated? Is it constitutional, statutory, procedural, evidence-based, jurisdiction-based? Step 2. Identify the jurisdiction. Ask, what court has authority? Municipal court, justice court, county court, district court, federal court. Jurisdiction decides the rules and the strategy. Step 3. Identify the remedy. Ask, What is the relief you are requesting? Examples: dismissal, injunction, suppression of evidence, release from custody, protective order, discovery order, monetary damages. Step 4. Select the correct motion or writ. You do not complain in court. You file a motion. You petition a writ. Examples: motion to dismiss, motion for summary judgment, motion to suppress, motion for continuance, motion to compel discovery, motion for reconsideration, petition for habeas corpus, petition for mandamus. Step 5. Follow deadlines. Deadlines are not suggestions. They are the gatekeepers of rights. Missing a deadline can permanently destroy a claim. Step 6. File properly. Court documents must follow required formatting, required captions, proper case number, proper court identification, proper legal citations, required signature blocks, certificate of service. Improper filings can be rejected. Step 7. Serve properly. Serving documents is mandatory. The court must know the other party was properly notified. Improper service can cause dismissal. Step 8. Make the record. A legal record means objections are spoken on record, filings are time-stamped, transcripts are requested, evidence is introduced properly, exhibits are labeled. If it is not on the record, legally it did not happen. Step 9. Preserve error for appeal. To appeal, you must preserve error. That means you raised the issue at the correct time. If you did not preserve it, the appellate court will not review it. Section 9. The most important writs in American law. Writs are legal commands issued by courts. These are the major ones. Writ of habeas corpus. Purpose: challenge unlawful detention. Meaning: produce the body. The government must prove authority to hold the person. Writ of mandamus. Purpose: force a public official or court to perform a required duty. Used when an agency or court refuses to act. Writ of certiorari. Purpose: higher court reviews a lower court decision. This is used heavily in appellate practice. Writ of prohibition. Purpose: stop a court from acting outside its jurisdiction. Writ of quo warranto. Purpose: challenge a person's authority to hold office or act in a legal role. Section 10. The 3 real courtroom weapons. Most cases are won by 3 things. 10.1. Procedure. Procedure controls the flow of the courtroom. 10.2. Evidence. Evidence determines what the judge or jury can consider. 10.3. The record. The record is what survives the courtroom. The record is what gets reviewed. The record is what protects rights. Section 11. The philosophical foundation. Law is applied morality. Studying law naturally leads into philosophy, because law asks deeper questions like, what is justice? What is truth? What is fairness? What is authority? What is legitimate power? What is the duty of government? This is why constitutional study leads people into Socrates, Aristotle, and Kant. Socrates concerned justice and truth. Socrates challenged society with one question: what is justice? Socrates taught that law must be examined. Blind obedience is not virtue. Aristotle concerned structure and purpose. Aristotle taught that societies are designed. Government must serve a purpose. A good society is one where laws help people develop virtue and stability. Kant concerned moral duty. Kant taught that morality is based on duty, not convenience. A system is legitimate only if it respects human dignity. This is directly connected to constitutional rights. Section 12. Why this matters today. If a person understands this system, they can protect their property, their family, their land, their freedom, their rights, their business, their reputation. Without this knowledge, many people become victims of
default judgments, unlawful detentions, administrative abuse, predatory contracts, loss of property, procedural traps. This training exists to stop that. Section 13. Final principle. Rights without action are not rights. The Constitution does not protect passive people. The Constitution protects those who know how to file, object, appeal, document, preserve, and build a record. Because the law is not only what is written, the law is what is enforced. American law comes from England, shaped by common law, equity, and the Magna Carta tradition. The Constitution is a structure built to restrain government power. But modern court victories are not based only on truth. They are based on procedure, evidence, and the record. If you master those three, you master the legal battlefield. End of Practical Legal Training Module, Part 1.